liberal, and I don't think that they require, they certainly don't insist that experts' publications have been peer-reviewed. So, Your Honor, again, I really didn't come here to particularly re-argue that, but I do believe, would the court entertain,
a break?
Maybe 5 minutes.
Why don't we take a little more than that and resume at 10 minutes after the hour?
What did that mean?
What?
Irresponsible procreation? Illegitimate natural children? What's he talking about in there?
They're going to say whatever they have to. It doesn't mean it's true or that it's about you. You two certainly weren't accidents.
God, no.
So he was talking about us. Me and Elliot, specifically. To our faces.
Spencer, it's not...
Technically, his back was to us, Spence. He didn't even say it to our faces.
When I was 21 and she was 19, my sister was diagnosed with inoperable brain cancer. The summer I graduated from college, she died. I was the only biological child my parents had left. Losing Karen changed us all, not necessarily for the best. We all fumbled through the sadness for years after that. It really felt like we'd be devastated and broken forever. My 20s were so wrapped up in grieving and healing, but I eventually came out of it. And when I did, I felt crystal clear that I wanted a family. I wanted to give birth. I wanted to feel connected to my kids the way I had to my parents and Karen when she was alive. I was unequivocal in my desire to have kids and bring the best parts of my sister, our family, and our future together. The rest is pretty typical. My partner of 7 years and I started the process of learning how to get pregnant. Yes, lesbians have to learn how. I went to a considering parenthood class for lesbians. We chose a donor. We started inseminating. And after a year and a half, I decided to use fertility medication. And that's when it worked. I got pregnant the spring of 1994. I was 8 months pregnant on my 30th birthday and bigger than our little house. You boys were born at UCSF on October 30th by C-section. I will not give you the OR details. But you were not accidents. You were not irresponsible. You two are about the most responsible, important, meaningful things I will ever do in my whole life. And don't you ever let anyone ever make you feel any different. You got it?
Yes, Mom. Yes, Mom. But we still don't want to eat out tonight.
Fine, tacos, take out whatever you want.
Hey, it's our turn. If you want to hear the rest, we should go back in. Come on.
Now, you believe that gays and lesbians today are raising children, correct?
Of course, yes.
And in fact, hundreds of thousands of children are being raised by gay and lesbian couples. Is that correct?
I don't know how many.
Did you ever try to find out?
I did.
And were you able to make an approximation?
I was. Yes, sir, I was.
And what was that approximation?
I can't recall.
Can you recall approximately?
No, sir.
Okay. And you recognize that in some cases, gay and lesbians are raising a child that is the biological child of one of the parents, and in some cases, they are raising adopted children. That's correct?
Those would be two yeah, of course they would be. Those would be examples of those will be examples of children in gay and lesbian homes, yes.
And you believe that permitting gay and lesbian couples to marry would significantly advantage the gays and the lesbians themselves and the children that they are raising. Is that correct, sir?
When you say advantage, do you mean improve the well-being of?
Yes.
My answer to your question is that I believe that adopting same-sex marriage would be likely to improve the well-being of gay and lesbian households and their children.
In fact, the studies show that all things being equal, two adoptive parents raising a child from birth will do as well as two biological parents raising a child from birth, correct?
No, sir, that's incorrect.
Well, sir.
Well, may I say another word on that?
You'll have an
please?
opportunity to redirect.
Okay, well, it was a clarifying thing, and it actually supports something you just said. The studies show that adoptive parents, because of the rigorous screening process that they undertake before becoming adoptive parents, actually on some outcomes outstrip the biological parents in terms of providing protective care for their children.
Yes, I was going to come to that. I appreciate you for getting there. Now, in binder number 1, we have a copy of your book, Future of Marriage. And the last two sentences. After all, part of the reason why the principle is so revolutionary is that it can grow and deepen over time. Groups that had long been considered effectively outside its moral reach, African Americans, women, people of certain colors or languages or religions, can over time, and often as a result of great struggle, enter into its protective sphere. And then you get to two sentences I want to particularly direct your attention to. You say, I believe that today the principle of equal human dignity must apply to gay and lesbian persons. You see that?
Yes, sir. Yep.
And the I there is you, correct?
That's correct.
And you say that in that sense, insofar as we are a nation founded on this principle, we would be more, emphasize more, American on the day we permitted same-sex marriage than we were on the day before. And you wrote those words, did you not, sir?
I wrote those words.
You believe them to be correct?
Yes, I now believe them. That's correct.
Your Honor, I have no more questions. When they come into court and they have to support and defend their opinions under oath and cross-examination, those opinions, they just melt away. There simply wasn't any evidence. There weren't any empirical studies. It's made up. It's junk science. And it's easy to say that on television, but the witness stand is a lonely place to lie. And when you come into court, you can't do that. And that's what we did. We put Fear and Prejudice on trial.
Your Honor, Mr. Blankenhorn's testimony was utterly unnecessary for this proposition. Utterly unnecessary for this proposition.
This goes back to the you don't need any evidence point. Mr. Cooper, carry on.
The plaintiffs think that the consequences dominantly will be good consequences, but is not something that they can possibly prove. And we would submit to you, because I have heard this and read this more than any 3 words that I have ever spoken. I don't know. I don't know how many times I wish I could have taken those words back.
Well?
Because, Your Honor, whatever your question is, I damn sure know there's a risk. And we want to see what happens in Massachusetts. We want to see what happens right here and elsewhere.
But the "I don't know" or "we don't know where it's going to lead" answer, is that enough to impose upon some citizens a restriction that others do not suffer from?
We don't have to prove that redefining marriage to include same-sex marriage would visit harm upon the institution and the interests that it serves. Rather, we only have to prove that including same-sex couples would not serve those interests. The California Court of Appeals actually upheld the traditional definition of marriage, and one of the points it made, Your Honor, really goes to the heart of the matter. It is the proper role of the legislature, not the court, to fashion laws that serve competing public policies. There's a debate about the morals and the practicalities and the wisdom of this issue that really goes to the nature of our culture. And the Constitution should allow that debate to go forward among the people. Thank you.
Thank you, Mr. Cooper. Mr. Olson, why don't we just begin at that point that Mr. Cooper just left off with? And that is, in a sense, isn't the danger not that you're going to lose this case either here or at the Court of Appeals or at the Supreme Court, but that you might win it?
Well, I think the case you're referring to has to do with abortion, Your Honor.
It does indeed.
Your Honor, the cases upon which we rely have been entirely different cases. They have relied on fundamental, established constitutional law, because the argument that Mr. Cooper makes is essentially the same argument that was made to the Loving Court, which, by the way, the Loving Court unanimously decided to strike down. And we stand here today thinking, how could that have been? In 1967, that's only 40 years or so ago, we would have punished as a felon in the state of Virginia the president's own mother and father if they had tried to travel there and be married. Now, Mr. Cooper's argument is, and I know why he would like to take back these words, we don't know. We don't have to prove anything. We don't have any evidence. Yet, he was reading from articles written by various persons who did not come into this courtroom and testify under oath, and who did not subject themselves to cross-examination by my colleague, Mr. Boies. Some of them didn't come into court because they had been cross-examined by Mr. Boies in their depositions. But you do have to know. He does have to prove. The Romer Court specifically says, under the lowest standard of review, you have to prove that you have a legitimate interest and that the subject, Proposition 8 in this case, advances that legitimate interest. So how does preventing same-sex couples from getting married advance the interest of procreation? What one single bit of evidence is there that they are a threat to the channeling function? If you accept that California has the right in the first place, and I do not, I believe, Your Honor, that there is a political tide turning. I think that people's eyes are being opened finally. People are becoming more understanding and tolerant. The polls tell us that. There isn't any secret in that. But that does not justify a judge in a court to say, I really need the polls to be just a few inches higher. I need someone to go out and take the temperature of the American public before I can break this barrier and break down this discrimination. Because if they change it here in the next election in California, we still have Utah, we still have Missouri, and we still have Montana. This case is going to go to a court. Some judge is going to have to decide what we've asked you to decide. And you have to have a reason, Your Honor, and you have to have a reason that's real, not speculation, not built on stereotypes, and not hypothetical. That's what the Supreme Court decision tells us. And I submit, at the end of the day, I don't know, and I don't have to put on any evidence. With all due respect to Mr. Cooper, does not cut it. It does not cut it when you're taking away the constitutional rights, basic human rights, and human dignity from a large group of individuals. You cannot say after the fact, we are going to take away the constitutional right to liberty, privacy, association, and sexual intimacy that we already tell you you have. That is not acceptable. And it's not acceptable under our Constitution, and Mr. Blankenhorn is absolutely right. The day we end that, we will be more American. Thank you.
So if there's nothing further, Mr. Cooper.
Nothing.
Very well. The matter is submitted.
Now what?
I know. It's too late for soccer, but we're going to go home. We'll just pick up food on the way, and you can study for your tests.
And what? We're just supposed to wait? Yeah, how long do we have to wait?
I'm not sure, Elliot.
Well, why not? I mean, you've got all these lawyers and people in suits running around. I mean, somebody's got to at least have an approximation of how long we have to wait. I mean, come on, give me a break.
Come on, we'll fight these guys another day. You've got soccer practice tomorrow. You've got tests to study for.
Fine. Mom? Mom.
What? What is it?
This whole thing was just ignorant. I hated being here.
You're right. You're right. You shouldn't have had to have been here. It's my fault. Okay, I'm really sorry. Elliot, I am. I'm just